Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho o imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º curso de inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
Hello, everyone. Hello. Hello. Can I begin now? Okay. Hello, everyone. My name is Maria de Lourdes Albertini. I'm professor of international law at Catholic University of Minas Gerais and at CEDIM. And first of all, I would like to thank all the people of CEDIM to invite me to be the hoster of this lecture today. This year, we are very, very happy because despite all difficulties that the whole world are facing because of the pandemic, we had the chance to hear great names of the international law because of the technology. So we are facing a paradox here. But let's move on with everything we are prepared today with Professor Thouvenin. I would like to introduce him. Professor Thouvenin is a professor of international and European law at the Université Paris-Nanterre. I'm so sorry, my French is terrible, since 2001. He is also a Secretary General of French Society of International Law and Director of the Center for International Law of his University, Nanterre. He has been elected Secretary General of the Hague Academy of International Law in 2017. He also a member of the French Society for International Law, of the American Society of International Law, and also associate member of the Institut de Droit International. He acts as a member of editorial boards of different international law yearbooks, including Annuaire Français de Droit International and the Peruvian Yearbook of the International Law. He is also editor and co-editor of several books, for example, A Traité de Droit International de la Mer, and the influence of human rights of international law. The first one, 2019, the second one, 2015. Also, he was appointed as a legal advisor and advocate in a number of cases before the International Court of Justice, including for Ukraine, Colombia, Chile, Iran, and Cameroon. He also appears before the ITLOS and the PCA and the European Court of Justice. Today, Professor Thouvenin will talk with us about the international sanctions, more precisely of the articulation between the United Nations and the unilateral sanctions. First, he intends to explain for us some terminological points and then turn to three hypotheses where unilateral sanctions are implementing, substituting, or contracting United Nations sanctions. Okay, Professor, take the floor, take the screen, and let's begin. Thank you very much to be here once again.
Thank you very much for this so nice presentation. It's too much. Perhaps the best glory of my career has been to teach in the CEDIN of Belo Horizonte twice, and I think it's an honor to have been invited for the third time to participate to this online session. It's very strange. In fact, I'm in the Hague. I want to tell that to the people who listen. I'm in the Hague in the Peace Palace. Normally, at this moment, we have the summer courses of international law by the Academy of International Law, and I think that all the Brazilians know that. Every year we have perhaps 100 Brazilians coming to the Hague Academy of International Law, and but this year we cannot do it because of the COVID-19. I hope we will be able to host students in January again, but anyway, we will do it in next summer. So I'm hosting you at the Peace Palace virtually, and to give you some insights on international sanctions indeed. So perhaps some of the people listening know that I've given a course in the CEDIN Belo Horizonte on international economic sanctions some years ago. And perhaps some of you also know that I've given a course on economic sanctions in the Hague Academy of International Law in 2017. So I want to address a specific topic, not to repeat myself. And the specific topic is indeed the articulation between UN sanctions, so the United Nations sanctions, and unilateral restrictive measures. So why this topic? Well, of course, international sanctions is nothing new in international relations, and everybody talks about the first sanctions adopted during the Hellenistic period. So that's nothing new, and normally I used to also recall that Napoleon was very keen of adopting sanctions against England, la perfide Albion. So that's nothing new, but the contemporary practice is very complicated by the number of sanctions, the abundance of these sanctions, and this raises many questions about the nature of these sanctions, their effects, and their legality or illegality. And one of the complexities is due to the authors of these measures. Sometimes it's the UN, so the United Nations adopt sanctions. Sometimes it is states alone, or sometimes groups of states, a collective group of states. So the question arises, how these sanctions fit together. And this is the topic I want to address. So it looks like a very narrow topic, but in fact, I think it's fitting correctly to 2 hours courses and 1 hour discussion. As has been announced, before articulating things, it is necessary, in my view, to give some precisions on the notions we have to discuss, the terminology. So we will talk about sanctions. What does it mean exactly? Restrictive measures, collective, unilateral. All these are notions that should be clarified. And of course, when I will clarify this notion, I will give my vision of these things. And no doubt that other people will have different views. So that's my conceptions of this terminology that I will bring to the fore. Then, and I'm not sure we'll have time today to go very far on this then, but then we will indeed evaluate this different situation where a national measure will be implementing a UN sanction or going further a UN sanction or contradicting a UN sanction. And that are hypotheses all very interesting. So let's first focus on the terminology and bring some conceptual considerations. So very simply, I think there is not a long time to pass on the notions of collective and unilateral measures. It doesn't need a long discussion. Everybody can understand what it means. Measures adopted by a single party, a single state, are said unilateral, while measures adopted by the United Nations are said collective. That's easy. And we say collective when we talk about UN measures in reference to Article 1, Paragraph 1 of the UN Charter, of course. However, I must say that sometimes it is said that measures adopted by more than one state, so for example, a group of states, are multilateral. So we hear sometimes about multilateral sanctions, for example, adopted by the European Union. It is said multilateral because you don't have one state alone behind measure, but you have, 27 states. My view is that it is confusing, and I do not like this usage of the notion of multilateral. It is confusing because generally multilateral is an equivalent to collective. When we talk about multilateral, we talk about something which is collective, which is worldwide. I'm not very happy with the notion of multilateral measures when it comes to a group of states adopting measures. I would prefer to talk about something like, it's less sexy, but I think it's more accurate, coordinated unilateral measures. So you have different states adopting unilateral measures which are coordinated. Now, let's turn to the notion of sanction. I will not enter into the theory of what is a sanction in international law. This is what I did in the sit-in some years ago. But my point here is to look at how it is used. And it is widely used to refer to UN measures, United Nations measures, not involving the use of armed force. Measures adopted by the UN in order to obtain from a state or another category of person that they adopt or abstain to adopt a certain behavior. In practice, these sanctions are adopted by the UN Security Council pursuant to Chapter 7 of the Charter, but the General Assembly could also adopt such measures. And so this is something that we sometimes forget, but the international lawyers know that there is a famous Resolution 377, the resolution uniting for peace, also called Resolution Acheson, because of the name of the promoter of this resolution, Dean Acheson. And under this resolution, adopted by the General Assembly took the power, or rather interpreted the Charter as giving it the power to adopt measures in case when the Security Council do not fulfill its own responsibilities with respect to the restoration or the maintenance of international peace and security. And under this resolution, it is absolutely possible for the General Assembly to adopt economic sanctions. Now, it will not be compulsory, contrary to UN resolution adopted by the Security Council, which are compulsory for states, but it will be anyway, it will be sanctions. Well, so we talk about sanctions easily when it comes to the UN. I think that everybody can check that by looking at the website of the Security Council, and you will see that there is a UN sanctions regime, there is a sanctions committee. So the notion of sanctions is very much accepted there. And it is a little bit surprising, to be honest. It is a little bit surprising because, first of all, you don't see the notion of sanction in the UN Charter. In the UN Charter, when it comes to Article 39, 41, and 42, you will find the notions of measures, that is a neutral term, and also the notion of action. An action can be taken under Article 42. But you don't have the notion of sanctions. And the second reason why it is a little bit astonishing to talk about sanctions in this context is that for a lawyer, normally the sanction is a reaction to a violation, a breach of the law. So the sanction is something coming after a breach of the law. By contrast, the UN Security Council is not supposed to act in reaction to breaches of the law. The Security Council is supposed to act to maintain or restore international peace and security, which is a little bit different, right? So the Security Council is not mandated to make justice in terms of enforcing international law. It has been mandated to preserve international peace and security, full stop. So the usage of the word sanction can feel a little bit uncomfortable in this context. But it's accepted for, I think, two reasons, which it can be debated, of course, but it is accepted for three reasons. First reason, in fact, in virtually all the cases when the Security Council adopts measures to restore or maintain international peace and security, it is against a state which has violated international law. You know, the breach of peace and security is always associated with a breach of the law. So you cannot have, well, it's very rare to have a situation when there will be no violation of international law, but a breach of peace and security. So that's the first point. There is a connection between peace and security and respect of the law. The second reason is that the UN Security Council adopts measures sometimes in order to obtain that its own decisions are respected. Its own decisions are the law, they are compulsory, and if they are not respected, the Security Council adopts measures in order to have these decisions respected. So that's indeed the idea of a sanction, because the decision of the Security Council, which is not respected, is the law. And the third reason why it is accepted and not a problem to talk about sanctions when it comes to the UN is that the UN has both the legal capacity to adopt these measures. So it has been mandated to adopt these measures. Just take a look at Article 41 and 42 of the UN Charter. And it has the legitimacy to do so. So if the organ we talk about is empowered to adopt a measure which is looking like a sanction and has the legitimacy to do so, well, it is not a problem to call its measures sanctions. It's even rather normal. Now, let's turn to another more complicated point, which is when people talk about sanctions when it comes to unilateral measures adopted outside the United Nations by a state or groups of states. So, for example, and everybody knows that, when the United States adopts a measure against another state for any reason, and God knows that the United States have many reasons to sanction the whole world, people say it's a sanction regime. It's a sanction. When the European Union adopts a measure, it's a sanction. So the word sanction is everywhere and loses a little bit its, a meaning. And this is the problem I want to cope with. We talk about, of course, measures that are adopted by a state. It's a unilateral measure in order to put the pressure on another state to obtain from this other state a change of its behavior. That's what we talk about. This other state has done something bad according to the sanctioning state, or has not done something that was expected, and then there is this measure which is adopted. So in this context, normally lawyers would not talk about sanctions. They will talk about measures, but not about sanctions. One advocate of the word sanction in this context was Roberto Ago, so a very prominent Italian international lawyer. When he was special reporter of the International Law Commission, he advocated the term sanction in this context. But in fact, the ILC, the International Law Commission, did not accept that. It was in the minority. The majority said, no, it doesn't work. And they elected to talk about these measures under two terms: retortion and countermeasures. So with these two terms, the ILC seemed to cover almost the whole range of non-military retaliatory measures that could be adopted by states. So what is the difference between retortion and countermeasure? The retortion is a measure which is unfriendly, but not unlawful. There is nothing precluding an action, but this action is not friendly. For example, a state says, I don't want your ambassador any longer on my territory. The ambassador should go away. So that's unfriendly, but it's not unlawful because nothing obliges a state to have an ambassador on its soil. That's a retortion. A retortion can be a response to an internationally wrongful act. It's possible. It's in the range of the possibilities, but it can also be, of course, a response to a perfectly lawful act. For example, I'm not happy with a declaration. A state is not happy with a declaration on tweets by the head of state of another state, and so adopt a measure of retortion. A tweet by itself is not a wrongful act. It's not contrary to international law. And the retortion can be a response to that sort of action. By contrast, countermeasures are measures adopted by an injured state, a state which has been injured by a wrongful act. And this measure is itself a wrongful act. So the very notion of countermeasure is that we have a wrongful act answering to a prior wrongful act. And the countermeasure, of course, is in the hands of the injured state. That's the notion of countermeasure, which is referring to the reestablishment of an equilibrium between the relations. And in fact, the countermeasure should cease when the first wrongful act ceases itself. So that's the notion of countermeasures. Now, of course, you will think, well, it's not covering all the range of measures adopted by states against other states. okay, we have retortion, unfriendly but lawful, countermeasure, unlawful apparently but lawful because it is responding to a wrongful act. It's a circumstance precluding wrongfulness. But there is a third hypothesis, of course, which is where the unilateral measure is simply wrongful. It's simply violating international law without being covered by the notion of countermeasure. It is simply a wrongful act. So I have an example to give to you, which is, in my view, the sanctions adopted by the United States against Cuba. This is not a countermeasure. There is nothing to respond to by the United States against Cuba, since something happened in the 1960s, so that's a bit long ago. But the United States measures are, in my view, wrongful because they are contrary to the principle of non-interference. They are violating many, probably also rules of human rights and humanitarian law. This is what Cuba say, at least, and I think they have quite good arguments in this respect. But that can be debated, of course. Anyway, everybody can see that the measures adopted by the United States are not countermeasures. So that's the third hypothesis that could be mentioned. Now, there is a fourth hypothesis to evaluate here, which is where you have what we call third-party measures. So the assumption here is that you have a state which is not injured by a violation of international law. A state is not injured, but is concerned because it considers that the violation of international law is important. It's a violation of erga omnes obligation. It is attempting to the international community as a whole. So the third state decides to adopt a measure against the wrongdoer with a third-party measure. So the question is, what is the regime of these third-party measures? A third-party measure can be a retortion, of course. So if the third-party measure is lawful, there is no problem that international lawyers have to deal with. For example, again, you can have a decision by the European Union to stop commercial relations with another state, and it can well be covered by an exception of the WTO law. The GATT contains an Article 20, which says that in certain circumstances you can put aside your obligations under the GATT, and then the measure is lawful, right? So it can be something like that. It can be also something resembling to a countermeasure. So is it possible to say, to qualify a third-party measure as a countermeasure? And the answer of the ILC is no, because the International Commission discussed this topic when it discussed the articles on the responsibility of states for wrongful acts. And the ILC said, we won't talk about third-party countermeasures, despite the fact that some experts were proposing that. So the ILC said, no, I will only talk about lawful measures in order to leave open the discussion about the regime of these third-party measures. And why did the ILC do so? The ILC did so because if it had accepted the notion that third-party measures can be countermeasures, that would have meant that the regime of the countermeasures would have been applicable to the third-party measures. And in fact, it doesn't match very well. I mean, the regime of the countermeasures is very peculiar. In order to qualify a countermeasure, you must fulfill a series of conditions. And it's not completely fitting with the notion of third-party measure for the protection of the community interests, for example. And so the ILC wanted to leave that open and to leave it open to, a further codification of international law. And for the moment, we don't have this codification. So we basically don't know what is the regime of a third-party measure which would breach an obligation of international law as a response to a violation of international law which does not injure this third party. So the regime is not fixed. There is a practice, but the regime is not fixed today. And we can perhaps discuss that later because it's a very challenging question. And in fact, it's so challenging that Alain Pelé, and I think that a lot of you know who is Alain Pelé, and he will give, or he has given already, a course during this session. Alain Pelé has recently argued in a paper he made for the Institut de Droit International, Institute of International Law. He argued that these third-party measures should be called sanctions. So that's very interesting. Alain Pelé says sanctions should be kept for the United Nations measures. Like me, I say the same. But he adds the third-party measures adopted for the protection of community interests, right? The interest of the international community as a whole. These third-party measures, even if not adopted by the United Nations, should be called sanctions as well. And so, by doing that, Alain Pelé is trying to fill the gap of what is the regime of these third-party measures. The moment you call that sanctions, you begin to consider that they are lawful, they are legitimate. And this is a little bit what he does. And what he says in order to justify this position is that, first of all, these third-party measures are flourishing, in fact, in practice, as I said, when the United Nations Security Council does not fulfill its own obligations, its responsibilities, because of a veto. So that's what he observed. He says, well, the third-party measures are not necessary and are not adopted when the UN Security Council does its job, but when it doesn't, because of a veto, then you see in practice these third-party measures. So that looks like, they look like really, they are like sanctions, like UN sanctions, despite a veto. Second, he suggests, that's my interpretation of what he says, because it doesn't go as far, but this is what I understand from what you read in the middle of the lines. I think he suggests that in contrast to countermeasures, which can be very easily confused with a sort of self-help, a countermeasure is a measure that you adopt to protect yourself by violating your own obligation to obtain that the other state will respect its obligation due to you. By contrast with countermeasures, the third-party measures are not at all to be confused with self-help, because the third party acts not for itself, but for the sake of the humanity, for the sake of the collectivity, for the sake of international as such. And so it is far more acceptable to talk about these measures as sanctions because of that. So that's I think the two ideas that are conveyed by Alain Pelé on this point. My view is that it would be confusing to call these third-party measures sanctions. So I don't follow Alain Pelé on this proposal. I think that sanctions should be kept for the UN Security Council and the UN General Assembly and not accepted for qualifying third-party measures. I think that the question of the regime should be left open, and that we still have work to do on that. And why do I think it is confusing? Because a sanction is supposed to be adopted by a certain authority, someone, some body, some institution that has the authority to adopt a sanction. The UN has it because of the treaty, the Charter of the UN. A third-party measure is based on nothing like that. And so this is quite complicated to accept the notion of sanction in this context. There is no legality and there is no authority to adopt sanctions when it comes to third parties. I say that to a certain extent, contrary to the European Union's position, but I do think that the European Union has no authority to replace the United Nations. That simply does not work. So I hope that this clarifies a little bit what are the notions to be used in this discussion. But I want to finish the terminological discussion by saying that the term sanctions, when it comes to unilateral measures, can in fact make very good sense insofar as it is supposed to name insofar as it is supposed to name the domestic regime of these measures. Take the example of an embargo. What is an embargo, really? It's a domestic legal regime, which is providing that the people who do not respect the embargo will be fined. There will be sanctions. So, for example, if the European Union adopts an embargo on Cuba, if me, Jean-Marc Thouvenin, I begin to trade with Cuba, I will be sanctioned by the European Union. In fact, by my state implementing the European Union regulation. So there is a sanction in this regime when it comes to the domestic legal regime. My understanding of what happens is that indeed, everybody talks about sanctions referring, without knowing it really, referring to the domestic system put in place by states when they adopt this sort of unilateral measures, but confusing this notion of sanction with the objective of these measures, which is to put the pressure on another state. And this pressure on the other state, in my view, cannot be called a sanction. It can be called a restrictive measure. It can be called a measure. It can be called whatever you want, but not a sanction as such. I can illustrate the notion of sanction in the domestic regime by recalling something which in France we very much know, which is that a bank which is called BNP Paribas has been sanctioned indeed by the United States, billions of dollars, because it did not respect an embargo on, I think it was Libya and Sudan, or perhaps Iran and Sudan. And so the sanction, in fact, did not eat Cuba or whatever. It has eaten BNP Paribas. But this is because it's a domestic regime of sanctions, in fact. So if you want to call them sanctions, referring to the domestic regime, that's okay. When it comes to international law, I think it's not correct to call that sanctions. As I said, the European Union and some others give the name, qualify these measures restrictive measures. So restrictive measures, that's the terminology which is used by the European Union's legal text. In fact, in the political text, they use sanctions. In the legal text, they use restrictive measures. And I think that the notion of restrictive measure is quite good. I think it's the correct term. An embargo, indeed, it's a sanction when it comes to the domestic legal system that applies the embargo, but it's a restrictive measure vis-à-vis the first state. It's restricting commerce with this first state. So that's in my view, that's fitting quite perfectly what we talk about. A restrictive measure can be a retortion, it can be a contempt measure, it can be a breach of international law as such, and the European Union accepts that. That's quite interesting to see that the European Union has adopted a guideline regarding its restrictive measures, and it says very openly the restrictive measures can be lawful, they can be countermeasures, and they can be unlawful. And in this case, the union should discuss with its members how to deal with this unlawfulness. That's very interesting to see that in the guideline of the Open Union. So that was my point regarding the terminology. So to sum up, my position is that in international law, sanctions should be kept for the authority having the legitimacy to adopt these sort of sanctions, namely the United Nations, be it the Security Council or the United Nations General Assembly. If it is the Security Council, it is compulsory. If it is adopted under Chapter 7, if it is the General Assembly, it is not compulsory. And we will take a look at what is the legal effect of these sanctions of the General Assembly later. And when it comes to states which adopt unilateral measures against other states, you can have different situations according to whether they are breach of international law or not. If they are not breach of international law, you can call that retortion. That's okay. That's a classical term, and it's defining quite well, I think, this sort of measure. If these measures are contrary to international law, for example, violating a treaty, so there is a treaty obligation which is not implemented, now you will have two hypotheses. The hypothesis of a countermeasure. So if it is a countermeasure, if it is fulfilling the conditions of a countermeasure, it will be a circumstance precluding wrongfulness. So that will be okay when it comes to international law. If it is not a countermeasure, it's simply a breach of international law. And there are many breaches of international law in the contemporary world. Now, when it comes to third-party measures, the same reasoning applies, save that we don't really know what is the regime of a third-party measure which would violate, which would breach an obligation. So is there a new circumstance precluding wrongfulness that is not already codified by the ILC, according to which if it is really a third-party measure and under certain conditions, it will be there will be no responsibility? Or are these third-party measures against international law engaging the responsibility of their authors? That is a question that is not settled now. Since I've still some time, do you want to break now and to begin a discussion and then pass to what follows, or should we finish the 23 minutes? Oh, I'm sorry. So I can't hear you. So I assume that it means that I should go on. I cannot hear you. No. Okay, I will.
Now, can you hear me now?
Yes.
Yes. Okay. I don't know. Maybe it was a problem of my my system here. Well, it's up to you.
Okay.
We have a little delay here.
Okay, so I will go on with my substantial part, which is to discuss the articulation between UN sanctions and unilateral restrictive measures. So after having discussed the terminology, now I enter into the substance of my point, which is the articulation.
Mm-hmm.
Now,
all right.
And then I will stop at 60, and then we can discuss.
All right.
So the first hypothesis is quite obvious. It is the hypothesis where unilateral measures are not really unilateral, if you want, because they simply implement a United Nations measure. As you may know, a United Nations sanction cannot operate by itself. In fact, when the United Nations adopt a sanction, it is saying to its member states, you should implement what I say as a sanction in your domestic systems. This is how it works. The United Nations does not directly commands to the people in the territory of states. There should be a nationalization of the sanctions by the member states. So you will have necessarily, when you have a United Nations sanction, national measures implementing this sanction. So they will be unilateral, if you wish, because they are adopted by states, but in fact they are adopted to implement a multilateral sanction. So in practice, it's really common ground to find this sort of measures, of national measures, even in the United States. And that's the funny thing when you look at that, because one could think, and perhaps there are some Americans listening to that, but perhaps they will think the same. You may think that in the US logic, it would rather be the UN which should implement the US measures than the reverse. Indeed, when you look at the history of the sanctions adopted against Iran, that's very striking. In fact, the UN sanctions regime against Iran reflects the success of the US lobbying of the world to sanction Iran after the 1979 revolution, reflects this success of this lobbying announced with transparency by Section 4 of the United States Iran Sanctions Act of 1996. So that's really how it works in the logic of the US. The UN should implement the US sanctions rather than the reverse. But in fact, when you look closely to the United States laws, you will see that there are many laws that do implement or provides that the President of the United States cannot implement United Nations sanctions. So, for example, the Section 8516 of the US Code provides that the President of the United States has authority to implement United Nations Security Council resolution imposing sanctions with respect to Iran. So that means that the President of the United States has authority under the US laws to implement the United Nations sanctions. You have the same sort of law in Australia, you have the same sort of law in Canada. I'm sorry, I did not look at the Brazilian law, but it's really common ground in national legislations to have this possibility for the executive to implement United Nations sanctions. The European Union also usually expressly adopts decisions implementing United Nations Security Council sanctions, and we have many cases in which the European Union regulations simply copycats the content of United Nations Security Council sanctions. So that is not a problem. That is really a situation which is easy to assess when it comes to international law. If the measure is a pure implementation of a UN sanction, it is lawful. It is lawful because of what? Because, first of all, it is adopted as a compulsory obligation under the UN Charter, because, as you know, the member states have the obligation to implement the Security Council's resolutions adopted under Chapter 7. And second, Article 103 of the Charter says that when you have an obligation under the Charter and another obligation under international law, you must respect the obligation under the Charter, which is having primacy, right? So basically, the unilateral measures adopted in this context are lawful, or you should think that perhaps the United Nations sanction is unlawful, but that is not impossible. But I think that no one will never be mandated to say so. The Security Council has no judge, and so it's very hard to find anyone who, with authority, will have the capacity to say that a UN sanction is unlawful as such. There is a second point. There is, however, a small difficulty here, which is as follows. To which extent a measure which is mirroring a UN Security Council sanction immune from any critics under international law? To which extent? Is there a limit to that? So I just said that no one will never, I don't know, but no one now has the capability to judge a UN Security Council decision. The ICJ is not entitled to that. It could be, it is not. But a national measure can be scrutinized by others, judges. For example, European Union's regulation can be scrutinized by the European Union Court. And so the question is, to which extent the implementing measure is immune from any critic under international, because it is a mirror of a Security Council decision. And on this point, we have, of course, we have an experience with the European Union in the famous Caddy case. So that's a case famous in Europe, at least, and a little bit in the world, because this case led to a change of the practice of the UN Security Council, which tried to better respect its obligation to respect human rights when it comes to adopting sanctions. Perhaps you know the Caddy case, but I will explain to you quickly what it is about. It was about sanctions adopted against people, not against states. It was sanctions adopted in the context of the fight against terrorism and against the financing of terrorism. And Mr. Caddy had been considered by the Security Council as someone financing terrorism and was sanctioned. It was put on the blacklist of the UN Security Council. Now, the European Union implemented this sanction by freezing the assets of Mr. Caddy in the European Union. So freezing the assets of someone is something very hard to leave. You know, you have a credit card, it doesn't work any longer. You go to the bank, you cannot have your cash. And so how do you leave? You don't know. So that's very, freezing the assets of someone is a very, very harsh decision. It is supposed to be, an administrative measure, but it's very, very much punitive, right, in terms of effect. Now, Mr. Caddy said, well, it's not me. I'm not responsible for anything I'm accused of. But no one never asked me. I never had the capability to defend myself. And so Mr. Caddy claimed against the European Union, saying, well, the European Union, by adopting this regulation against me, is not respecting the right of defense, the basic rights to defend itself against any adverse measure. And so the European Court had to deal with this point. And it said that, yes, indeed, even if the measure is a mere mirror of what the Security Council ordered, the Union must respect the right to defense and must give to Mr. Caddy the right to defense. Which means that if Mr. Caddy proves to the European Union that he is not responsible, the Union will not implement the decision of the Security Council, which creates a new problem because, of course, the Union has the obligation to implement the UN Security Council resolution. And so that creates a complication. And this is why after the Cadi decision, the Security Council tried to improve its process in taking decisions and in reviewing its sanctions adopted against persons. And now there is an ombudsperson which has been put in place in the UN to be the contact person toward which the person under sanction can go and claim and ask for a withdrawal of the sanction. I've heard that it works, and that now the how do you say it in English? The mistakes, the judicial mistakes, if I may say so, are more rare. I have another point here, which is what if the implementing measure goes further what has been decided by the Security Council? Will it be covered by the immunity in international law that is deriving from the fact that it is an implementation of a lawful measure, or will it not be covered if it goes further than what has been decided? Now, logically, one would think that if the measure goes further, the part of the measure going further than what the Security Council did should be assessed as such. Is it lawful or not? Right? And this is what a lawyer would do. But at the same time, what is arguable is that to the extent that this measure is prolonging a UN Security Council decision, the very reason why the Security Council has adopted it works as well for this extension. And so the legitimacy of the measure is kept alive, even if the measure is extended. And to this extent, I would tend to think that the target state will have more difficulty to prove that this extension of the measure is unlawful because it is legitimate. So I don't confuse legitimacy and lawfulness. That's two different things. But the legitimacy can play a role in the legal debate, however. A last point when it comes to the measures implementing UN measures, UN sanctions, a last thing is whether, the last question is whether the national measure of implementation can be extraterritorial. So here is the hypothesis. We have a UN sanction and states have to implement it. But the fact is that they don't implement it correctly. All of them are not correctly implementing the sanction, and there are some holes in the system. One state is unhappy and says, if the others don't do that right, I will do that for everybody. And then this state will adopt extraterritorial sanctions. You follow me on that? That's a bit tricky, but this is something that can happen in the context of North Korea. You know that there is a sanction regime against North Korea, but some states do not follow this sanction regime correctly. For example, China and some others, perhaps Russia to a certain extent. And so the United States has a tendency to say, hey, I want the system to be coherent. I want the sanction to be efficient, so I will implement extraterritorial sanctions. Now, the fact is that when you look at the resolutions of the UN, none of them, I didn't see any of them, authorize or mandate the recourse to extraterritorial measures. None of them. And that's really logical. In fact, the UN is talking to its member states, and there is an assumption, there is a presumption that the member states will respect what the Security Council says. So the United Nations does not need to say to one of its members, hey, act for the others. And so you will never have, in my view, it's even impossible to think a UN resolution authorizing the recourse to extraterritorial sanctions. So what does that mean? That means that if there is an extraterritorial sanction, it will be assessed under international law as such. It will not be assessed as a prolongation of a Security Council decision. It will be assessed as an act that should be assessed under international law. Is an extraterritorial sanction authorized or not by international? That's a big question, a complicated question, but that would be the question. Yes, so I think that's all I have to say about the unilateral measures implementing United Nations sanctions. And to sum up, there are 3 points. One, it is very common ground for states, and I'm sure that Brazil does the same, to adopt national laws implementing on the territory, under the jurisdiction of the state, the sanctions adopted by the UN, like an embargo, like a freezing of assets, any sort of sanctions. So that's very common ground. Second point, what if the national measure go further than the UN measure? How will it be assessed under international law? My view is that it will be assessed as such. It will have to be justified as such under international law, but at the same time, because it is a mere prolongation of a measure adopted by the UN Security Council, the causation of this measure is the same. It's in principle legitimate, and so it will be complicated for the target state to prove that there is a breach of international law. I don't say it's not possible, I just say that it will be more complicated. And by the way, I never saw complaints by states under such regime that they were under a breach of international law. And third, when it comes to national measures of implementation, no resolution authorize or mandate states to adopt extraterritorial measures in order to render the system more, the sanction more efficient. It doesn't exist. So if a state adopts extraterritorial sanctions said to be mirroring UN Security Council sanctions, it will not. It will have to be assessed under international law as such. So I think that's the first part of my presentation, and perhaps we can now have a discussion.
Okay. Thank you very much, Professor. Thank you. We have a little delay here. Thank you. It was a very interesting presentation, very important for us. I have many doubts, but I shouldn't put my doubts here right now, because most of them are related with the retaliation that we used there in WTO when a country refused to follow the decisions of the appellate body and of the resolution system at WTO. So I don't think so. It would be interesting to put this situation right now, but I have many doubts about it. And I would like to go to the questions of our students. We have some questions here, if you prefer. It was very interesting, and I would like to make an observation that we have a problem last year with a ship of Iran that was the Petrobras refused to to fulfill the vessels and that were carried with corns, and it was U.S. asked us to put an embargo against. It was a domestic embargo, in my opinion. This was very famous case for us and very important. We have a decision of the Supreme Court, of Brazilian Supreme Court, that told Petrobras, you have to fulfill, to have to put fuel in these ships, and because these ships are carrying food, and you need to let these ships go away, and so on. And then it was proceeded. The Supreme Court decision guaranteed the conclusion of the corn exportation operation of Brazil. It was a very interesting case. So, but let's move on. I will make the questions for you here, if you let me do it. First of all, it is the case of Korea, North Korea. And Natalia, one of our viewers, asked here, good morning, Professor. I would like to know your opinion about the sanctions adopted by the US and other countries related to the North Korea nuclear problem, and if you think that they are the best solution to approach the country and its regime. Would you like to hear all the questions first, or you would like to answer them? And
no, I think I can answer them as you put them, so that we can change subject.
Okay.
Yeah. So it's, in particular for this sort of question, which is of course interesting. Is it the right way of doing? So it depends what you call a right way of doing. Is it efficient? It doesn't look like very much. So that's the first point. And so if the assumption is that a politic to be right should be successful, that's not the politic which is successful. So that's not the right thing to do. Now, is it lawful to adopt sanctions against North Korea? In fact, it's not the United States alone. In fact, there is a UN regime against North Korea on this point. And it's a quite tough regime on North Korea. And as far as I know, the United States is implementing this United Nations regime. And more than that, I think that the United Nations try to keep the control on these sanctions. And so this is why the United Nations goes relatively far in the sanctions adopted against the regime in order to keep the United States under control, if I may say so.
Yeah.
Now, of course, the United States is acting also alone, but via tweets mainly, and tweets are, it's not really a sanction. And so, is it the right way of doing? Well, are there any other solution? Now, is it a solution? It doesn't work for the moment. So what can I say?
Yes. Okay. Yes. We have a diplomatic problem before the sanction. Yes. Can go further?
Sorry, no. What do you mean we have a diplomatic problem?
I mean that before we have the sanction of the United Nations against North Korea, but before it, we can't avoid the sanctions because we have to solve the problem between North Korea and the world after the war that separates the two Koreas. I mean,
it's an old story, yes.
Yes, a historical problem. Historical problem. Yes. Okay, let's go further because we will not have time to answer all the questions if you not be very focused here now. Nicolas Pere, historically, would you say that sanctions tend to achieve their objective as effectively changing the behavior of another actor?
Well, in fact, no. And this is why there has been a huge change in the 1990s. Until the 90s, the sanctions were embargoes, general sanctions, eating the whole population of a state. And that was common ground. It was a weapon, a peaceful weapon that was supposed to be less damaging than the war. And so states and the United Nations as well had recourse to this sort of embargo without reserves. And that's what happened with Iraq. Perhaps you remember that. And everybody discovered that it didn't work. In fact, Saddam Hussein was reinforced by the sanctions, and it could not achieve the objectives. And so in the 90s, there has been a shift, and the international community decided to adopt focused sanctions, what we call smart sanctions, right? So the idea now with sanctions, normally, the idea is to hit directly those people who are responsible for the politics that are supposed to be bad. And so you will, you will target Kim Jong-il, you will target perhaps Putin or people around Putin. And so that's the current trend. Does it work? It doesn't work well, in fact, but it's less damaging in terms of humanitarian law, etc. And this is because it's not working that in vis-a-vis Iran, as you also, the United States is putting in place a maximum pressure policy, which is eating everybody in Iran. It's not eating the ayatollahs and the president, whoever. Even if they have killed someone recently, it's not a sanction, it's a use of force. They put in place a policy of maximum pressure, strangling completely the whole country. And why is it so? Because the sanctions did not work until then. So the question is, well, if for having an effect, the sanctions should be so hard, so harsh, is it a good solution? I'm not sure. I come from an old age when diplomacy, and you were talking about diplomacy at the time, diplomacy was the right way of doing to settle the problem. Nowadays, not diplomacy any longer, sanctions, and it does not work. So the sanctions are worse and worse. And then what? So yes, I think we have a problem with sanctions. I think we still have a problem with sanctions.
Okay. Yes, I tend to agree. And this is the problem of WTO. WTO is quietly finishing its activities because of the sanctions and the single undertaking regime and so on. But let's go further. Now we have Leticia, and she asked, complementing Cassio's question. I'm sorry. Cassio question. Cassio Coutinho. Good afternoon, Professor. Are USA sanctions against the ICC an opportunity to debate and perhaps abolish the possibility of referral by the United Nations Security Council in the court's proceedings?
I'm quite sure that the United States horrible move against the ICC judges and personnel will have no effect on the law as it is applicable in the ICC. So I don't think they will have any effect. What I can say is that I'm in The Hague, and so I meet the judges, and they just don't understand what's going on. They just don't understand. And they were very happy to see the international community saying, that's rubbish. How can you do that? So I think that it will pass. There will be an election and it will be forgotten.
Okay.
That's an epiphenomenon. I mean, the sanctions adopted against the judges, etc., that's something crazy. So it doesn't deserve a long debate. It should be considered as rubbish.
Okay. And Leticia complement the question of Cassio, asking Is it possible to use this strict terminology of sanctions to such measures against international institutions and organizations?
No, but we talk about United States measures, right?
Right.
Yeah, and so my position is that it's not sanctions. When it comes to international law, now it is sanctions in United States law, because what the United States law says is that if the judge adopts such a certain behavior, I will freeze his assets on my ground. I will freeze the assets of his wife, of his relatives. Yes. That's, and so that's a sanction in the US, but in terms of international relations, it's not a sanction. It's a sort of, it's a sort of aggression against intelligence.
Yes. Yes, I agree. I put an observation here. They are unlawful sanctions, but they are adopted unilaterally by a country.
I don't know if it's unlawful. That's the problem.
No.
Why is it unlawful? I had no reflection on that. Is it unlawful for a state to say, because of any reason, Mr. X will have his assets frozen on my soil? Is it something forbidden by international law? Under what law? Human rights? Perhaps the rights of property? Yeah, rights of property. Humanitarian law? I don't think so. Perhaps United States laws? That could be an issue. Immunities? So that there's probably an immunity point to rise here. But since the United States is not a party to the ICC, I'm not sure, and I'm completely sure that the United States does not recognize any immunity to the judges of the ICC. They have an immunity vis-à-vis the member states, not vis-à-vis the United States. So I'm not. That's the problem. I'm not sure that the decision of the United States to hit these judges is unlawful under international law. It's unfriendly. It's ridiculous. It's how can I say? Disgusting.
Non-diplomatic.
Yeah.
Non-diplomatic.
Yeah, I stay diplomatic.
Measure.
But I'm not sure it's contrary to international law. I'm not sure.
Okay, thank you. So let's move on. Fernando Porto is asking, Professor, what would be the legal implications to the United Nations if the United Nations Security Council adopts a sanction in violation of obligations incumbent upon the United Nations itself, such as perhaps certain human rights obligations? That
was the big issue in the UN in the 2000s, and it was related to the Caddy case I talked about.
Yes, Caddy case.
And so now the Security Council tries to be controlled by himself. So that's the idea. In fact, the Security Council does not want to be controlled by anyone outside itself. So, for example, the International Court of Justice, but it accepts to be controlled by its own organs. So it creates an ombudsperson and things like that. Now, the hypothesis you put is, and if, anyway, the Security Council violates human rights, what happens? Now, I think that the response should be from member states. As I said, the Security Council cannot act by itself. There is no army, there is no police, there is nothing like that. So the Security Council must act on basing itself on its member states. So if the Security Council takes a decision that is at odds with international law, with the human rights, my assumption is that the member state will resist and will say, well, no, we don't implement that. And there will be a contradiction, of course, because normally they have to respect the decisions of the Security Council, Article 25 of the UN Charter. And so they will violate that and create a crisis. And if there is a crisis because the Security Council violates human rights, well, we will have to find a solution.
Yes.
the crisis can lead to a new, chapter in the history of the UN. Today, there is no solution.
Okay, I agree. And Ana Clara also just said, I think the questions asked by Cássio and Letícia are very relevant, and I'm very curious to hear what Professor Thouvenin has to say about this sanctions against international organizations. And let me put the other question, because this is just a commentary. Rodrigo asked, how to avoid that United Nations sanctions targeting a state and its officials can target the people and economics of that state, in order to avoid that well-intended sanctions violate people's human rights? Oh, always the same question of $1 billion.
No, for the first question, no, I agree that it's interesting to put the question of the legal regime of unilateral measures targeting international organizations. I do agree, it's an interesting question. For example, what if the European Union is targeted by a unilateral measure of the United States? The European Union is an international organization, right? So it can be targeted by the United States. But, we discussed that. Whether the unilateral measure is a retortion, that's okay. Perhaps it's a countermeasure, perhaps not. And if it is not, it is unlawful. Or it is nothing at all. But if it is unlawful, then the question is, who will say that? And today, we have an example. The European Union says that the United States extraterritorial measures hitting European Union's persons are unlawful. The European Union writes that and claims that it's unlawful in international. The United States says, we don't care.
Yes. And
so what? And so you don't have a possibility today to go to a judge and to have the judge saying, what is the law? So yes, the question is interesting, but everything comes to, at the end of the day, what is the measure? What is the law that is infringed? And to come back to the judges of the ICC, this is my point. My question is, and I open that for the debate, and perhaps you will have an answer, what is the law which is infringed by the United States when they say, I will freeze the assets of the judge XYZ for any reason on my territory? What is the law which is infringed? Okay. I'm not sure I know, right?
All right. Yes. Okay.
And I come to sorry, you had a second question at $1 million. How do you do to avoid that sanctions are hitting people who have nothing to do with the wrongdoer? So that's the notion of smart sanctions, right? So there is this smart sanctions that is nowadays implemented. And for example, the European Union has adopted smart sanctions against Russia after the taking of the Crimea. So basically, they are hitting, the European Union is targeting banks, the Russian banks and Russian personnel, members of parliament and members of the government. So it doesn't touch my friends who live in Russia. I have many friends in Russia. They are not hit by these sanctions. But the thing is that it's not efficient. So that's why the sanctions is not a solution in any case.
Okay. All right. Okay. We have a delay here. Okay, thank you. And now Maurus is asking, dear Mr. Thouvenin, why do you think that sanctions are limited to the United Nations Security Council and General Assembly when the Charter recognizes regional agreements in Article 52, maintenance of international peace and security?
Yeah, it is the same question as the WTO, in fact. Of course, you can have a treaty by which the parties say we mandate a body to adopt measures sanctioning those of us who do not respect the agreement we passed together. That's common ground. In the European Union, you have a mechanism by which a state can sue another state because this other state did not respect the European Union law. And at the end of the process, of the judicial process, there can be sanctions, monetary sanctions. So, but that's not interesting. I mean, that's not my point. My point is to talk about the sanctions that are not covered by a special agreement.
I
right?
see.
Yeah, it's the same. If the United States does not pay the fees, not the fees, but the money they owe to the United Nations, and this is something they do sometimes, they can be sanctioned by losing their right to vote. That's a sanction.
Okay.
But these sort of sanctions are not putting any problem, in my view, in general international law. That is pertaining to treaty law. While my question about the sanctions is not about treaty law, establishing system of sanctions. It's about international relations at large.
Yes.
So to answer the question, I do agree that in certain treaty, you have system of sanctions that are established. That's okay. But that's treaty law.
I think Leticia made a question that complements what you were talking about right now. Professor, you can mention that the legitimacy of an extended sanction related to an United Nations Security Council resolution is kept. But what if the causes of the United Nations Security Council sanction ceased to exist? Would the legitimacy remain? To go a little bit further that you were talking about.
That's a very, very clever question. Very clever question.
Yes.
Very smart. PhD student, probably. So the thing is, I was not very clear on that. So this is why it's a smart question, because it puts the finger on something which was weak in my explanation. In fact, what you may see is that the UN Security Council resolution is compulsory. By contrast, a recommendation of the UN General Assembly is not. Now, my assumption here is that a sanction going further what the UN Security Council orders would be covered by something resembling to what would be a recommendation, a sort of authorization, not an obligation, but a sort of authorization. Okay, this state has done wrong. The UN Security Council has adopted sanctions. And then you go further. Well, yeah, the wrongdoer is still wrongdoing. So you can have an authorization to go a little bit further. So that's the idea that is conveyed by what I said. So I say it's debatable. It's not very solid in terms of legal argumentation. But what I say is that in terms of legal debate, the one who goes further could argue that it is just implementing the goal pursued by the UN, even if it is not implementing the rule decided by the UN. So that's what I was trying to say. Now, if the sanction disappears, that means that if the United Nations withdraw the sanction, normally there is no legitimacy any longer to implement what was before the sanction. Now, there is an example, which is the JCPOA, which is the sanction regime adopted against Iran. So as you know, there was a very strict regime, UN regime against Iran, and it has been suspended, lifted, withdrawn, because of an agreement between Iran and the other powers and the UN and the European Union, sorry. And this agreement was called the JCPOA. Now, if the Security Council decides to withdraw the measure, you cannot pretend to implement the measure any longer. And so the United States cannot pretend to implement the measure any longer. They implement unilateral measures, and they are or they are not lawful. This is a question, we have discussed already, whether it is a retortion, whether it is a countermeasure, whether it is a violation of international law. So I think it answers the question. No, there is no possibility to say, well, yeah, I'm implementing something which does not exist any longer.
Okay, yes.
And even the goal, to be very complete, the aim that the Security Council wanted to achieve cannot be achieved through a sanction. This is what the Security Council decided vis-à-vis Iran. Now, let's place to the diplomacy. This is what the Security Council said, diplomacy and control. And so the one saying, well, anyway, I will implement sanctions against the United States, against Iran, is not implementing the goal, is not fulfilling the goal initially advanced by the Security Council. So that's completely different than when you go a little bit further than what a UN Security Council decision does.
All right. Okay. Yes. And last, but not least, if I'm not wrong, last year, Brazil adopted a law authorizing the United Nations Security Council sanctions under Chapter 7 to be implemented directly. And,
yeah, that is possible. But if a state decides to adopt such a law, the law is necessary anyway for the UN sanction to be implemented directly. Okay? So you need to have the passage through a law. And this is the law you talk about. You can have a law implementing each measure one by one, or you can have a law saying every measure of the UN Security Council, if it is published in the official gazette, should be respected by the local people. That's okay. But you always have a law or a constitution.
Yeah. Okay. All right. Okay, I think we have finished here. I would like to invite everyone to be with us again on the next Friday at the same time, 12 o'clock. Am I sure? Yes. And Professor, it was a very provocative discussion, and this is the main point of the debate, in my opinion, for the international law. I'm so happy to be here today and to be again with you in the next Friday. And it was very, very instigating for me.
Let me congratulate you, because I assume you had many questions in front of the eyes, and you have two brains, one looking at and talking. That's impressive. Congratulations for that.
Actually three, because my family is passing by here all the time. My kids, please, I'm working.
Okay.
Today. Okay, Professor.
Okay, thank you.
Thank you very much. It was a great pleasure. I'll see you then on Friday. Okay. Thank you.
Thank you.
Thank you. Bye-bye.
Bye-bye.